Good evening, you're watching Left, Right and Centre. I'm Nidhi Razdan. Tonight, the Supreme Court strikes down a new law on the appointment of judges which would have given the political establishment a say. The court cites political interference during the emergency. But should judges be appointing judges? Does there need to be a far more transparent system of appointing the judiciary? Well, that's a question we're asking on a day when the government reacted with surprise and disappointment to the Supreme Court ruling, the Attorney General calling it flawed. But many others have welcomed the verdict, saying that the new law on appointments would have amounted to interference by the government. Well, it's certainly quite an interesting debate, and the question is whether this is going to set the judiciary on a collision course with the executive. What will the government do next? Joining us tonight to debate this is a very eminent legal lineup. Indira Jaisingh, Prashant Bhushan and Raju Ramachandran joining us on the program tonight. Indira Jaisingh, let me ask you first, I believe you welcomed today's order in your comments earlier because you believe that political interference was something that would have been completely unwarranted. But would you also agree that the current system of the collegium at the moment, it lacks transparency, it is opaque, and we need to find another way?
I would agree with both the comments. First, that I welcome the judgment, and second, that the collegium system lacks transparency. You need to tell your viewers that the court has kept control over the case. The case is not over. It's going to continue on the 5th of November, and the court has invited suggestions for members of the general public and the legal profession on what can be done to improve the collegium system. I, for one, certainly plan to put in my recommendations, which will go towards ensuring that there is transparency, that there is accountability within the collegium. For example, every new proposed appointment must be made public with the CV and the biodata of the judge intended to be appointed, together with information about his antecedents, whether his father, mother, brother, sister have been judges of the court, asset declaration, etc., so that we know what is the quality of the person being appointed. And I think the court must also invite from us objections to the proposed appointment. So yes, I agree with both propositions. I'm in full agreement with the majority judgment of the court that we cannot allow the executive to interfere in the matter of appointments, but equally we demand accountability from the judges of the Supreme Court.
All right, Raja Ramachandran, let me take this to you. How do you view today's judgment then? Do you agree with the suggestions that Indira Jaisingh says that she would like to put forward on making every proposed appointment public, asset declaration and so on? Is that the way out, or does there need to be a recomposition of the panel that ultimately appoints judges? Your view, Mr. Ramachandran.
Nidhi, I am very dismayed by today's judgment. So there is no question of going along with my friend Indira and her suggestions about improving the collegium system. I think this judgment is fundamentally flawed. It may be considered as a great day for the judiciary by many, but I think it's a very sad day for democracy. If independence of the judiciary is a basic feature of the Constitution, so is democracy. So is the system of checks and balances. The judgment proceeds on the erroneous assumption that the executive is interfering in judicial appointments by the new arrangement which was proposed. The executive was only given a right to participate along with civil society, and the participation of civil society in judicial appointments is something which all of us have been clamoring for years. There is no question, as I said, of interference, but it appears that the judiciary thinks that participation of people other than themselves strikes at their independence. This, as I said, strikes at the root of the democratic principle. Let us remember that under our Constitution, we have given judges the widest powers to strike down laws of Parliament and judges have given themselves the power to strike down amendments to the Constitution. It is inconceivable that a body which is vested with such vast powers, the superior judiciary is essentially a political institution in the broad sense. It is inconceivable that this appointment process of judges should just be a self-perpetuating one of judges without the element of democratic accountability.
I think that's a very important point you make, and I'll take that back to Ms. Jaising in just a moment. But, Mr. Bhushan, just to take off from what the court said today, one of the things that was said was that since the executive has a major stake in a majority of cases, the participation, for instance, of the law minister as a member of the Judicial Accountability Commission would have been clearly questionable. They made a reference to the emergency and to political interference as well. Where do you stand in that debate? Is there some truth in this, that it's not as simple as the executive just being a participant, that there would have been political pressure, but at the same time, the way things are conducted today, there's a massive cloak of secrecy and complete lack of transparency about the way judges are appointed?
Yes, Nidhi, of course, there is a problem about transparency and the manner in which judges are appointed even through the collegium system. But what the Judicial Appointments Commission was seeking to do is to bring in substantial control or substantial say of the political executive in the selection of judges. Now, in order to understand why this is why this would have been bad, one needs to understand why the independence of the judiciary from the political executive and from the legislature is so important. Because under our constitution, one of the most important functions of the judiciary is to keep the executive within the limits of its powers, to protect the fundamental rights of citizens, to ensure that the legislature does not transgress the constitution and at least the basic structure of the constitution. That is why, and we have seen that independence of an institution also gets compromised if the person from whom you need to make it independent gets a substantial say in the appointment of the people in that institution. And that's what this Judicial Appointments Commission was seeking to do by bringing in the law minister and two eminent persons who would be essentially selected by the Prime Minister and the leader of opposition. Of course, the Chief Justice was also there, but clearly the majority was with the political class in selecting those two eminent persons who would be part of the Judicial Commission. And at a time when there is an unprecedented assault on our civil liberties, on freedom of speech, on the right to dissent, on diversity in this country, I think this judgment is a very welcome judgment and is a very important judgment to protect one of the most important or the most important bulwark against fascism or against executive complete.
No, but Mr. Bhushan, do you believe it can continue the way it does? Do you believe the collegium system needs? Do you believe that Mr. Bhushan? Do you believe that the collegium system does need a major shake-up as well? I've heard you say that in the past and talk about the lack of transparency.
Yes.
I mean, judges are appointing judges, and we really don't know what goes on behind the scenes and why certain appointments are made and how they are made.
No, absolutely. The collegium system certainly needs a lot of reform. In fact, I have been saying that we need a full-time body which is independent both of the government as well as of the judiciary. So you need a different kind of Judicial Appointments Commission, which is not an ex officio body consisting of sitting judges and the law minister, etc., who have no time to devote to properly select judges. You need a full-time independent body which goes about its job in a transparent and scientific manner. You first lay down a criteria for selection. You lay down how you will be judging the various people on that criteria. You advertise the vacancies, call for applications or nominations. Then you prepare a short list on the basis of your criteria, put out the short list in the public domain so that people can send their comments or whatever information they have, and thereafter the appointment commission selects people on the basis of the criteria and the system that they have laid down. Unfortunately, all that is lacking in the present collegium system, and that is why the Supreme Court has fixed the case for hearing from the 3rd of November.